Okay, so on this video, we're going to cover asset acquisitions, the term sheet or letter of intent. So essentially in any M&A deal or buying and selling a business, essentially, if you're doing it as an asset purchase versus buying the entire company, like an LLC or a corporation where you take it over, you're just buying the assets of the company and putting them into your own LLC or however you structure it. So usually you start the process with a term sheet or a letter of intent, an LOI. So I'm going to show you what a sample, just basic template looks like and some of the things that you can look for in that transaction. So let me share my screen and I will show you just a blank template. Okay. Okay, so this is a letter of intent for an asset acquisition template. This is based on a letter of intent versus a term sheet. They basically mean the same thing. It's outlining the material terms of an agreement to buy a business, sell a business. One is more of a letter format. The other is a kind of an outline of the terms. They both cover the same things. It's just the format really that's different or the terminology. So in this one, it's the buyer submitting an offer to the seller, and they're going to buy proposal to purchase the assets of a certain business that the seller owns. So they identify the parties. Okay, who's the buyer, the seller, and the company? And what are we buying? Okay, so this is the specifics of the transaction. Acquisition of assets. So as long as everything is, satisfied by both sides, then we are going to buy all of the assets and maybe take over some liabilities or debts. For example, if you're buying a truck that has a loan on it and a lien by the bank, you probably are going to have to take over the loan and the liability. Or same thing with real estate. If there's a mortgage, you might have to take over that liability. But in some cases, a lot of cases with an asset purchase, you don't want to take on really any liabilities. You're just buying the assets free and clear, which is what it says here, free and clear of all encumbrances. So basically meaning when I buy these assets, nobody has a lien on them. Nobody can come and take them away, foreclose on them, unless it's specifically identified. Like there's a mortgage and we're disclosing that to you. Purchase price. So first of all, who are the parties? What are they getting? Either all the assets or maybe you outline specifically, here's the list of assets that I want. Maybe it's not all of them. Maybe certain liabilities you'll take on. So you would outline all of that. This one just says all assets. So what's the purchase price? Okay, we're paying $1 million for this business or whatever it is. Some of it might be payable up front, and here's how you outline the payment. Okay, half of it's due up front upon closing by wire transfer. Maybe you put $100,000 of it set aside into an escrow account to be held for a year to cover any unknown liabilities, or there's a number of different ways you can do this. Also, you may have a note like financing. There might be a bank involved. So some of the funds might be coming from a bank. You might outline the terms of that. It might be, okay, here's an SBA loan for 50%. It's going to be paid by the bank. Or maybe there's a seller note. The seller is paying, essentially, the buyer's paying the seller back over time. So the seller is essentially financing the deal, acting as a bank, and so that the buyer has more time to pay, maybe over 2 years, 5 years, whatever it is. There can also be earnouts where the seller, typically the seller is going to want to stay on board to make sure that the company performs. But an earnout is where part of the purchase price is paid out through the future profit of the company. So the seller usually stays on board, runs the company, makes sure it's profitable, and to help pay down, basically it's a way of the seller almost earning their own purchase price. That's why they call it an earnout. But those can take, there's a lot of different terms that go involved on how those work, but that could be included in here as well, an earnout. So there may be an adjustment to the purchase price. So for example, if you sign this term sheet or letter of intent today, you close in 90 days. The balance sheet or the working capital, like how much cash is in the bank or accounts receivable, accounts payable, inventory, those numbers fluctuate in any business. So we have to take into account adjustments between now and when we close. So there may be some type of adjustment mechanism on how to adjust the purchase price for those changes in the business before we close. There may be other assumptions for where they're coming up with the purchase price. Maybe it's subject to a quality of earnings report, or it's subject to our due diligence review of your financial statements or something to confirm that everything that we've used to come up with the value for the purchase price is accurate. Once we have the basics of how it's getting paid, then essentially what this says is as soon as we sign this, we're going to hand it to our lawyers to start drafting agreements. There's going to be an actual asset purchase agreement, a lot of other secondary documents too. So there could be like an employment agreement for the seller to stay on or the current employees to stay on. There could be a number of different things that need to take place. Consent of the landlord to transfer a lease that has to be signed. So that all gets drafted up after this is signed. And also in here, it talks about escrow agreement, bill of sale, and assignment. Bill of sale and assignment are ways of transferring title to assets. If there's real estate, then there might be a deed and title company involved. Escrow agreement is if you're setting some of the proceeds aside to cover indemnification, to cover future liabilities, to cover something in the future where you have a pool of money set aside so that the seller can't just take all the cash and, move to Puerto Rico or Mexico or the Caribbean and disappear. So a lot of times you'll set money aside. Now, in order to close this transaction, what are the conditions? Well, the buyer is going to come in and do due diligence. They're going to look over, kick the tires, check out the seller and the assets, make sure they're getting what they think that they're getting. Obviously, receipt of any cash or debt proceeds that they're supposed to get. Otherwise, this is a financing contingency. So if the buyer is getting a loan from the SBA and the SBA says, or the bank or whoever says, no, sorry, we turn you down, then the buyer can't move forward. And so this gives them an out. It's a financing contingency. If we don't have our financing, we can't close and we can back out. The board of directors or anybody involved approving the transaction from a corporate perspective, making sure everyone signs all the agreements to close. There could be regulatory approvals needed. So maybe there's a license, permits tied to the business. Those might need regulatory approval, like a new permit or a new license or a transfer of a license has to get approved. Otherwise, the buyer can't effectively run this business after closing. So that's a contingency. You need that before you close. Also, third-party consents. This could be when you buy assets, you are taking the assets away from an LLC or a corporation and putting them in your own LLC or corporation normally. So if there was a contract between the prior business and a vendor, they might have a written agreement between XYZ LLC and this vendor. You take the assets away, you set up your new 123 LLC, that no longer is a party to that contract. So you either have to assign it and get consent and approval from that vendor or enter into a new agreement with your new LLC. So sometimes you'll put those consents as a condition in order to move forward. Same thing with a lease. If the property where the business is run is leased and you're going to continue to operate it there, you obviously need that lease to be transferred to your new LLC so you can keep running your business. So you want to have that as a buyer contingency. What about the transition period? What about employees? Are those people entering into an employment agreement? Do you need written agreements with the seller to continue working as the CEO for a year? Those all have to be either in writing or agreed to ahead of time, or maybe the buyer is bringing all their own new team in. And in connection with that, the buyer may ask for a non-compete. That's what this covers. So the seller or key principals or whoever agrees to not go ahead and set up a competing business down the street as soon as they sell. That's something that's usually negotiated. And just generally that between the time that we sell this or sign this letter of intent and the time that we close, there's been no material adverse change. In other words, nothing significant has changed to where I should, as the buyer, would no longer want to buy these assets. Usually you'll outline the due diligence period and saying from the day we sign this until maybe 30 days, 60 days, seller, you're going to let us either come to your property or give us access to anything we ask for, books, records, financials, contracts, and put in a data room or however it's transmitted. They may have a restriction in here that says that during work hours, the buyer can't come to our property and tell our employees we're selling because that could cause an issue. So you might have to cover that in the term sheet as well. And sometimes you'll have a limitation on the due diligence period where you have a 30-day due diligence. Unless you back out before the end of 30 days, then you're fully committed to move forward with this transaction. This same thing talks about employment arrangements. Are you going to offer employment even if you don't have a written agreement? Are you offering employment to all of the current employees or not? We just want to make sure that that's clear. And obviously you can't control what the employees are going to do. So usually you just put the seller's management is going to use its reasonable best efforts to help the buyer, get the employees to move over. Covenants of seller, this talks about essentially from the time we sign this until we close, the seller is going to continue to do business as usual, that they're going to act the way they have in the past. They're not going to make any major changes that could affect the business or the assets. Exclusivity is usually something that's typically negotiated. As a buyer, you're spending time and money looking at a potential acquisition. So you'll usually ask for the seller that for a period of time at least, that you're not going to go out and market and try to sell this to somebody else. So you might have a 60-day window or whatever the period of time is that we have exclusivity as the buyer. You can't sell it to somebody else during that period of time. And there's usually termination provisions that, hey, if we don't agree on something, then each side can walk away. If we don't sign the written agreement, then basically the exclusivity may terminate, or the buyer may be able to terminate early. Okay. Sometimes there's representations about that we're not under a current other LOI or term sheet with somebody else. What happens? How do we terminate this letter of intent? Well, if you sign a definitive agreement, an asset purchase agreement, essentially that terminates the term sheet because it supersedes, it's better than, it's controlled, like it's going to be 40 to 90 pages versus 6 pages. So it terminates then, or maybe there's provisions that each side has the right to terminate at some point, or both can agree. Now, when it comes to termination, there may be break fees on one side or the other that during a period of time, once due diligence is done, if the buyer walks away at the last minute, there might be some kind of a fee they have to pay the seller because now the seller's lost all that time between, the time that they've been doing their due diligence and everything else. Buyer says, hey, I decided I don't really want to do this. They may have to pay the seller some money. That's something that's commonly negotiated. Okay, so bid expiration. A term sheet or letter of intent is an offer. In order for the other side to accept it, they have to sign it. So if you've got multiple offers out there, you might put 3 of these out to different companies you're looking at buying and give the sellers a period of time. And if somebody else, like you give it to 3 different people as a buyer and one seller says yes, then you terminate the other ones. So you're not stuck having 3 different purchases. So you may want to say, okay, this is this offer is going to remain open for 48 hours. So you have that period of time to sign this. Governing law. So if there's a dispute over this letter of intent, do we look to the laws of California, New York, Texas? What law do we look at to interpret and resolve any disputes? Sometimes you also put in here that if there is a dispute, maybe you go to arbitration or mediation first, or you agree on where you would go. Like, okay, we're going to bring any kind of lawsuit would be in New York City, or it would be in Los Angeles County or whatever it is. Confidentiality, usually when you get to this stage, there's an NDA or confidentiality agreement already in place. So this basically says that that prior confidentiality agreement remains in full force. Obviously, if you didn't have one, we would expand this and make it into a full confidentiality agreement. This just says that other than the buyer and seller, there's nobody else that can enforce this. There's no third-party beneficiary. Expenses. Normally, each side pays their own fees, and there might be an agreement that the seller may say, "Hey, buyer, I pay your legal fees," or if there's real estate, we split the cost of escrow and title. So that's where this would be outlined. And also in a term sheet or letter of intent, typically you want to make sure you state that this is not a binding agreement. This is not the actual purchase agreement. We're going to sign a full agreement that's binding later that can be enforced. However, certain parts of this term sheet may be essentially, enforced. So confidentiality, the exclusivity, some of those usually you do say are binding, but the rest of it is not. We don't have to do this transaction. Then you might have some miscellaneous that each side can sign their own version. Headings are only for reference, and then everybody signs. So that's an LOI for an asset purchase. And essentially, when you do these, you want to make sure you cover any deal killers. You think about what are the main things that have to happen for this transaction to work, and material terms, getting those all on paper in writing, so that at least you have a general sense that we're on the same page. And so, yes, let's start moving forward. Those are the two main things to think about for a term sheet or a letter of intent. And you may have to, during the process, there's negotiation after the term sheet on all kinds of other areas, but let's get the main terms agreed upon to see if we can move forward. So that's an asset acquisition. Thanks for watching.